Well, good evening, everybody. Look at this, 23 people, keen as mustard. Can everybody hear me okay? This is Brian, by the way, checking in a couple of minutes before go time. Good day, Stephen. Good you can hear me. Sophia, Karishma can hear me. Okay, that's excellent. Volume okay, not too deafening, not too soft. Everybody good? Okay, let me know if I fade in or out so I can make adjustments. And I think I'll just check, but I think Paul's here. Not yet, perhaps. Okay, well, we've got a couple of minutes to go, and I think we might as well say welcome to our last Collaborate. So well done, everybody who's here. Nice to see you too, Paige, checking in from far away. And this is it, our very last one. So well done on making this far, on jumping the hurdles and getting your assignment 1As and everything. There we go. Paige is all the way in London. And what's the weather like there, Paige? Okay, Paul's coming in. Good evening, Paul. Right on the money. Hi, Rachel. Good to see you. Yes, Stephen's quite right. Probably warmer than Melbourne. As warm as our winter. Well, it's as Rachel says, it's freezing here. Hi, Paul. Okay, well, we might as well get this last one out of the way. The plan is to give you a bunch of exam tips and then get out of your way and let you study, because as nice as it would be to have us looking over your shoulder in the exam, it's really up to you now. We've done pretty much most of what we can do to help, and now we'll try and get out of your way and let you revise pretty shortly. So if you do have any questions, week 12, which is next week, is the time to ask them. Wow, we've just jumped up to 37. Hello, everybody. Okay, well, I'm going to go fairly quickly. Hi, Krishna. I'm going to go fairly quickly through my set, which will be pretty much about the exam. And the reason is, from what I've seen so far, you've all done really well, and pretty much most of you who've been paying attention have got the ILAC nailed. And I mentioned that I realized that you who've made the effort to come are the superstars. So sometimes a lot of what I say will be for the recording and perhaps for those who are later. So I'm not trying to tell the superstars how to suck eggs at all. Okay, so I'm going to go fairly quickly, and then Paul's going to go through a negligence example. Now, you may recall Dr. Ravi took you through one in Collaborate 4, and we'll just do it again, and that might give you something of a hint. So here's your pay for coming along. You can listen to the recording of that one, Rachel. But yeah, if Dr. Ravi did negligence and we're doing negligence, I think if I was a betting man, which I am, Sagittarian gambler, I would bet quite strongly on something about negligence. So there's the famous ILAC just there, so you can look at it every time if you need to. Again, I'm going to skate over it. The ones listening to the recording later can... Oh, okay, the ones listening to the recording later can read it. But basically, yeah, the only thing to avoid in the exam, which is slightly different to the assignment, but I did mention it a couple of times in feedback, which you'll see once we've completed the long, gory, gruesome moderation process next Monday night. We should be able to release them to you. What happens, just for those of you who don't know, is we tend to mark them, then they get sent to the academic on campus who goes through them to check that we haven't been too nice, in my case anyway, and that the marks are in line with the rest of the cohort. And once that's approved, then the faculty approves them, and then we're allowed to release them. So it is a bit of a grueling process, but we'll get them to you by midnight next Monday at the absolute latest. Rachel, I'll do my best, Rachel. Okay, now here's another hint for coming along. If it's an ACL question, that's Australian Consumer Law, by the way, Schedule 2 of the Competition and Consumer Act of 2010, you need to mention sections. So if you write a beautiful and quite true few pages in the exam, but you don't mention a single section, your chances of passing are probably somewhere between slim and very, very small. So just sections. Familiarize yourself with the consumer law sections. Everybody by now probably knows section 18, section 29, and there's a bunch of others. If you wanted me to reel a few off, what other kind of sections you should probably know, you can get them from a summary of the ACL, but things like 21, 22, 55, 18 we've mentioned, 29 we've mentioned, 50. Section 3, which is the definition of the consumer. A lot of you think already know that. Section 21 is unconscionable conduct. Section 55 is where goods are not fit for purpose. So, you know, you can download a copy of the ACL anywhere off the internet and have a quick look through it, or print it out and take it in with you if you like. You can take in any printouts, but you can't use any electronics. Yeah, section 50 is about harassment. And most of all, at the end, when you do your conclusion, put in some remedies. And if they're Australian consumer law remedies, then you're probably looking at section 243, which is declaring a contract void, or 224 to 231, which are things like monetary penalties. So you want to be flinging these sections out. That would be my advice, rather than just writing stuff with no sections. That's not necessarily the law. It could be just your opinion in the pub. Plenty of bush lawyers about, aren't there? Okay, so that's all I have to say about as Forrest Gump said. And you can put in cases, by the way, when it comes to consumer law. I'm just moving slides, but when it comes to consumer law, you'll see two kinds of cases: the newer ones which come under the Australian Consumer Law, and the older ones which come under the old Trade Practices Act, which is the oldest consumer law. And it doesn't matter, you can cite either or those cases if you think they apply. This was just a quick example. Most of you have got this down. This was a nice one from another unit where somebody used the AGC4 system, and for example, their law area, they put things like offers require specific terms by which both parties promise to be bound. Footnote 1, by the way, get my little pointer up. Hope you can see it if you can't sing up. And then down here, they mention the case. Now, here's the thing. This is assignment type stuff. In the exam, you don't have to do all this. You don't have time, and we understand that. In the exam, the only thing you've got to do is put either the section and what it's about, or the name like this here, R and Clark. You don't need all this 1927 guff, just the two names will do it. And of course, this bit, what they're about. So that takes the load off a bit. Yeah, I just wanted to show that for the purposes of a little bit of pre-assignment feedback. Quite right. Application, you all know, it's the detailed bit. Most of the marks are there. You can't say things like, from the facts, we can see there's an offer made. You've got to explain why. You've got to give a case. You've got to back it up with the law. Otherwise, remember, it's just your opinion. Looking at both sides, from what I've seen, as I say so far, everybody seems to have that well under control. Well done. And always cite case law. Citation, citation, citation. It's the law version of real estate, location, location, location. Okay, missing info. I've seen a lot of good stuff on that. I think you've got it. And nearly everybody's putting the impact of it, which is important. So great. Super duper. Nothing really to beat up on there. And conclude. And in the conclusion, I mean, it doesn't matter where you put it. We're not going to say, oh, the remedies is in the wrong spot. But it's a good spot to just put in the remedies. Like remedies for breach of Section 18 can be found at Section 243 or blah, blah, blah. So it's a good spot to wrap it up and put your remedies in. What can they get for their troubles? Okay, so now if everyone's still awake, am I dreaming or are there actually 65 people here? Oh, maybe it's 65 chat messages. Sounds more like it. Yeah, 14 is more like it. I can see numbers climbing, but I think I'm counting chats. 14 people plus us. As they say in the shipping business, 14 souls. And we don't count the ELAs because they have no souls. Okay, well, this is a little bit now about the exam, if everyone's still with me, and happy to hear that. And I'll give you some tips and tricks as far as I know them. And then I'm going to hand over to Paul for an example. But let's see what we got. Now, most of you will know this. So you can find some information in Canvas under assignment 2. Don't worry about the times in there. They're all gibberish. For some reason, it says it'll be held at 00:00 or something. I don't know whether they're capturing bin Laden at 0:30 or what's going on with that, but it's wrong. And I have asked them to correct it. So who knows? Maybe they'll have the right time soon. But you should get your individual advice. So everything I say here or we say is overruled by your individual notice that you should get or have got. So that's it. 3 hours. You've got 3 scenario questions, although the third one I'll explain is broken into subparts, which are shorter. So you've got 2 kind of like the longer practice questions you see in the weekly discussions. It's worth 50% overall. So the smarty pants among you will be arriving at the exam room with a good sort of 40 odd in your pocket. So that should take the pressure off a bit. You're aiming for an HD, obviously, but it shouldn't be too hard if you've done well in the term to pass it, but it'll be hard to get an HD. It does occur that people write, say, a brilliant bit of stuff and they don't cite anything. And then when they get the result, they're like, how come I didn't get an HD? Well, there are reasons. And similarly with the assignments, we go through a very involved process where it's marked, then it's marked again by the academic who looks at them and checks that they're all okay. If anybody at all gets a fail mark, that is remarked twice to check there's no way we can get you over the line. So we're not here to, trip you up. We're here to try and help you in every way. And so once all that process goes through, that's why it takes a few weeks as well to get the results. But we go through a process to protect your own interests. And if you do end up not doing too well, you probably we'll probably be able to tell you, but we don't give feedback on final exams. Reason being, you can't really improve in the unit. So we try to give, Paul and I'll give you some feedback on the assignment because that might help you with the exam. Once the exam's over, it's cheerio, you're off. Probably doing another unit and forgot all about us. Okay, so anything printed, anything written should be okay. I would print it anyway to be on the safe side, but nothing technological, no dictionaries that are electronic or any of that. But it does mean you can print out learning materials, you can print out PowerPoints, you can print out just about anything, and you can take the text. So you've got that as a safety net. But if you rely on that 100%, take it from someone who's done a lot of these things, it's time that will get you. You really don't have the time to be looking everything up. The way I do it is I treat open book exams like a closed book one. I pretend it's closed book, and then when I blank out in the exam, at least I have a safety net, but if not, I already know quite a bit of the stuff. And I finish on time. The plan. Okay, so 3 questions. 1, 2, 3. Question 3 has 3 subparts, so they'll be a little bit shorter, A, B, and C. Question 3 also, as I'll come to later, is worth less. So you can tell where you're supposed to put in the effort by the marks allocated. The other 2 questions are worth 20 each. So there's an expectation that you'll do something pretty good there for 20% of an entire unit on one question. Yeah, sorry about the yellow, but I believe according to my info, that it's on the Thursday, the 13th of June. Now, if we have a look at that, because we're week 11 now, next week is revision, and then you would have a week to revise on your own, I guess. So yeah, that's why I say we're going to try and get out of your way and let you revise, which would be far more productive than trying to give you new information at this stage of the game. Whoa, it looks like Collaborate chewed that one up. I'll make sure the slide will be okay when I post it up anyway later today. Paul and I will still be around for week 12. At the end of week 12, as I'll mention later, the ELAs finish up. You may not be aware that not all, in fact, very few ELAs are full-timers, that we're sessional. You look at Paul, he's a family lawyer, and he comes in to do this because he enjoys it so much. Correct me if I'm wrong, Paul. And then the sessional contract is up and we're off. However, you'll find, because we're such beautiful people, that we quite often can't resist helping anyway. But if during that week 13, when you should be revising, you're desperately troubled about something, I'll check the boards. I won't guarantee the same speediness, but I'll definitely look in on them. And there's nothing at all to stop you talking to your colleagues during that time and swapping tips and tricks in the boards either. But yeah, I'll be around. I'll be there. I'm there for you. Okay, I'll translate this slide, but are there any areas you should focus on? Yes, there definitely are. Negligence, so I'd say check out Dr. Ravi's Collaborate rather than which one's their song in? I'll be there for you. I'll be calling you. I can't do the high notes. Yeah, we might have to write that one, Paul. Dr. Ravi did a Collaborate on this, which you may be aware of. He's had some notes which we put up. We're going to go through that today. Paul's going to take you through some ideas on negligence, how to approach it. He's going to go through an actual sort of example. And some of you may have already panicked and hit the bottle because you saw down below it says 75 slides. But we're not going to do 75 slides because there's a whole section that I just added as an appendix tonight, which is stuff about negligence, things about how it works and what to look at, which you can read in your own time. So we'll probably go to, I think we're going to about 50 max. So yeah, negligence. It's a tort, remember, and you'll learn a lot about it tonight if you don't know it already. Second one, definitely consumer law. So practice question 8.3 is a good one. You want to know the sections for unconscionable conduct, exclusion clauses, non-performance, some of the ones I mentioned earlier. Contract, possibly. We've done a lot of contract already, including in the assignment, so I would advise you to focus up on these first two, but don't necessarily forget everything you know about contracts. And then business structures, intellectual property, and employers' duties, they're lighter, but they might come into the short answer questions. So that's about the best I can say. Now, here's even more material. Question 1, we're allowed to tell you this, negligence, 20 marks. Question 2, consumer law. There's the week it was in, 20 marks. Now you expected to have its open book and you're getting 20% of the whole unit. So you need to pull the rabbit out of the hat on that one and show the assessors what you've got. And then question 3 will be broken into ABC, business structures, employment law, and IP. And that's only worth 10 marks overall. So what I do when everyone else rushes into the room and starts writing and think, oh my God, I'm already behind, I sit down and I do a workout if I haven't done it before, and you have the details so you can do it beforehand, something like this guy here. And I know that I want about 70 minutes for the first two and 36 minutes for the last. So if I start at 2 o'clock, I'll make that 60, 60, and 30. So I'll be ahead. And then I'll say, okay, 3 o'clock, I need that finished. 4 o'clock finished, and 4:30 that finished. And it's never failed me, that little 5 minutes of working out your timing. That way you know if it's 3:45 and you're not even halfway through, you need to speed up. Okay, anyway, that's my little trick that I use, so I thought I'd share it with you. If anyone does it, let me know how you go. Okay, so the best thing is to read the assignment 2 info under assignments. There's some info in there. I've seen out of the corner of my eye a few things on past exams. In week 12, which is next week, Paul and I will make available some stuff in there for revision. To be honest, the past exams, the unit has evolved quite a bit over time. At one time, we spent a lot of time on sale of goods. At one time, we spent a lot of time on interpretation of legislation and how judges interpret it and so on. So past exams may include questions that are completely irrelevant to this TP. Based on the little chart I just gave you, which is back somewhere here, I think if you did the focused on the modules and the weekly practice questions and were able to do the weekly practice questions blindfolded, I think that might be a better way of spending your time than doing past exams. But they are available in the library, and we'll see if we can dig some up if you really want them. But yeah, the practice questions in the module each year are revised to target what you're going to be assessed on. Lists of stuff, I know, I've been here, done that, got the t-shirt. You're supposed to do this, that, and the other, and everything else, and you never do, but it's nice to know what you could have done and what you should have done. And you can always, you know, join the military as a gunner. I was going to do that, and I was going to do the other. I'm a good gunner. But yeah, there it is. You can read it. Oh, it worked. Sorry, I panicked because I thought the slides had gone sideways. I'm a gunner. Is that what you're going to have, Mark? I actually, yeah, I just have to tell you, I got a great t-shirt. Of course, originates from Game of Thrones, but I love the t-shirt. It's brand new. I've only worn it once. And it says, I drink and I know stuff. That's what I do. So that's a cool t-shirt anyway for me. I like it. So also, yeah, the practice questions. That's what you've got to do. I do it to a timer because, again, you can have all the knowledge in the world, and the silly bit about exams is if you can't get it done in 3 hours, then you may not do well. So exam technique is probably, I would say, 80% of it. Practice to a clock. See if you can write out a practice answer and get it fairly well done in an hour, and do it over and over and over, and that takes about half of the stress out of the exam anyway, and you'll know exactly what speed you've got to move at. But we all know that time does bizarre things in the exam environment. It warps and shrinks and twists you inside out, so the more you practice that timing thing, the more you'll kill it. You can print all this stuff out, study guides, slides, etc., and so forth. Print to your heart's content and take them in. Don't swamp yourself, but, you know, we can take in any printed. I would always recommend the I like method. Paul will probably have something to say about this later, but it just ensures that you don't miss anything. When people don't use it, they tend to have very skimpy law sections, and this makes sure that you've got a short issue. All your cases are listed under law. You then apply the cases you've listed, bam, and then you conclude with remedies. And it's just make sure you've got it nailed. So I always recommend it. What else can I tell you? You pretty much know this. How to get an HD. Good, Paul's on board. He recommends it too. And as I think Paul mentioned in the last Collaborate, if you read the transcripts from the courts, they're actually using something very close to I like in the way they present stuff as well. And just, there we go. Yeah, it's time. That's what's going to get you, not knowledge. It'll be the timing. How much can you compress and get down, and how many sections and relevant cases and principles within the allocated time. So make sure you answer the question. A few people who clearly know their stuff, it'll say something like, what statutory remedies does blogs have? And they then go off and write about contract law, which is not statutory. Statutory is, acts and things like the Australian consumer law. I don't think there's anything tricky like that this time, but just read it really carefully, especially the last sentence of the question. And if it says, what remedies does blogs have under the Australian consumer law, then stick to the consumer law. But as I say, cases are brought to court under the consumer law, but make sure most of it is going to be sections. Of course, negligence and the law of torts is common law, so that'll be cases, not sections. Same deal under law, you would just put section this and section that. Section 18, misleading and deceptive conduct, but focus on this statute. Just at the last minute, if you find yourself caught out, do some dot points. We're definitely out there trying to give you marks, trying really hard, but if it's blank, we can't give you anything. However, if you say, oh, heck, I've got 5 minutes left, I've had it, one question to go, just scribble down some dot points. You might be able to, give us the opportunity to give you some marks for that. But you've probably all heard these tips anyway. I'm just clicking forward, but we're going quite slowly today. Oh, there we go. Yeah, week 12 is going to be all about revising in the exam, so not to worry. We'll be helping you out there. You can talk with each other in the boards and ask any questions you like during week 12. And that I thought was kind of amusing because I've experienced it myself. That's what the law professors say on the left, and that's what you hear on the right. Exam. It's coming. Haha. Rachel and Krishma, glad you liked it. Okay, so remember, that's what you're being tested on. It's your knowledge, your ability to answer stuff, not to just do a template answer or anything. So similarly with Paul now, I'm going to hand you over to him and he's going to take you through some negligent stuff. It's not a template, but it gives you some ideas, hopefully, and who knows, it might be worth printing out to take in with you, see what you think. And well, thank you, Rachel. I'm blushing. And now, without further ado, let me hand you over to my learned colleague, Paul, who can take you through some other stuff. So I'll come back at the end, but to wish you all the best, but I'll hand you over now to Paul. Thanks for listening, everyone. Thanks, Karishma.
Thanks, everyone. Thanks, Brian. Thanks so much. Can everyone hear me? Oh, good. Yeah, so thank you very much, Brian, for all of those tips. I hope that everyone listened very well to those tips. I agree as well that ILAC is the way to go. I think it's a really good way to set out your answer because, as Brian said, you don't miss anything. And I know that I said it last time, and Brian even said that I said it last time, but it's true that if you have a look at the way the courts have written judgments, the higher courts have written judgments in the last 30 years or so, compared to 50, 60, 70 years ago, which sometimes you have to read as a law student, you'll see that these days they're very much into structure, they're very much into setting things out very clearly. They talk about the question that they're being asked on appeal, say, so that's more or less the issue. They talk about the relevant legal provisions that they're going to apply. It's good that Mark's noticed that too. And then they their judgment is really the application. That's when they think about the case before them in terms of the law, and then at the end they say what they're going to do, what orders they're going to make, based on their analysis. So that's the conclusion. So they might not call it those, use exactly the same subheadings that we use, but it's very, very much the same process. It's a very logical process. It's a very process that makes a lot of sense. So, yep, I'm just responding to Mark. Include a remedy in the conclusion. That's a great place to include a remedy. Because also another thing is that a lot of the questions, if you notice, the way that they're asked is you have to give advice to someone. And if you think about if that was a real person asking you for advice about their legal problem, you could probably sit in there and rabbit on about the law, rabbit on about cases and talk about a whole bunch of things. But really what the person's interested in is the remedy. They want to know, well, firstly, they want to know what their chances are they're going to win or not. And then what do I get? What do I get out of it? So for them, it's really, really important, the remedy. Sometimes it's the most important thing. So I think we should always include, and as Brian said as well, we should always discuss the remedy. But obviously, as you know, we're students here, so we're very much interested in your thinking, the way you apply the law. So whereas a real client might sort of tune off a little bit if you start going into the law, Brian and I aren't going to be tuning off. That's going to get us excited. So we really want to see a very good application. But yeah, don't a good rounded answer would also include the remedy. And I think it's worthwhile thinking that you're actually giving advice. It's not it's not just an academic exercise. Just think, yeah, this person has come to me for advice. Where's it all going to head to? That's really what they're wanting to know. But obviously, as I said, we're going to be asking you to go into the law in as much detail and with as much thoughtfulness as you can. That's really what we want to see. All right, so we'll have a look at negligence now, and obviously, as you've seen, negligence is going to be an important part of the exam. So we've already looked at this for 1 week, and also we had Dr. Ravi's Collaborate session, which was really, really good. So that was a couple of weeks ago. So that recording's still up, and I've posted the slides. I'm sure Brian's posted the slides from there as well. So those slides are, in fact, at the end of these slides too. So we won't repeat what he said, but they're here for your reference as well. So I'll post these slides after the session so that you can have a look through them. So with negligence, there's a 3-step process. Firstly, it's important to figure out who the parties are. So the parties are generally the person suing, so the person who wants a remedy, they're the plaintiff, and then the person who it's alleged to have been the one who's done something wrong. So they're the defendant. They're the one that the plaintiff is saying, you were negligent, you were careless, it was because of you that I got injured. So as we've said, there's for any of the questions, there are always there's always a legal test that applies. And for negligence, there are 3 elements that need to be established, that the court needs to find proven in order for negligence, for a finding of negligence to be made. So for liability to be found, each of these 3 things needs to be proved. So we've gone through this before. Firstly, there's a duty of care owed to the plaintiff, that the defendant breached the duty of care, that's number 2, and then that breach caused the damage and the damage was not too remote. So we'll go through these in a bit more detail. But there, you've always got to put that in your law section. and you can also consider defences as well. So remember, there are a couple of defences to negligence. So you need to work through those step by step. You need to state the law, the relevant cases. So this is mostly case law, although you will see that some of the law has been put into statute as well, and you can always cite that. And then important, applying the law to the facts given in the question. So this is the vital bit. This is what we're talking about with the application, the vital part, where you get to think about it, where you get to show your thoughtfulness, where you show how much you know. All right, so duty of care. So remember, the first thing that we've got to think of is the relationship between the plaintiff and defendant such that there's already a duty of care? So there's a text number here, 220. So if you have a look at that page in your textbook, you'll see that there's a lot of established categories of duty of care. For example, motorists owing a duty of care to other road users, doctors owing a duty of care to patients, and there's a whole list, and there are cases there. So first have a look if there's already a duty of care established by way of that relationship, and then if there is, then you can quote the case and explain the relationship. If there's no pre-existing duty of care, then you need to apply the neighbourhood test from Donoghue and Stevenson. And just as an aside, for all those established duty of care categories, at some point they would have applied this test. The courts would have applied the neighbour test and found that there was a duty of care. It's just that it's already been done. It's already been settled, so we kind of don't have to revisit it. But if you've got to examine whether there's a duty of care, you need to apply the neighbour test, and that's what we'll look at now. So the question is it reasonably foreseeable? So was the plaintiff's harm a reasonably foreseeable result of the defendant? Okay, so you need to look at the facts and the circumstances of the case, and is it just and reasonable to impose a duty of care? So remember, the neighbour principle was that who is a neighbour? There's someone that can be reasonably seen to be affected by any of your actions or omissions. So omissions are things that you don't do. So anyone that might be reasonably foreseen to be affected by the results of your actions or omissions, they're your neighbour at law. So that's the first part of the test. And then there's the second part, that you've also got to show that the salient features of the case are consistent with the existence of a duty of care. So that basically means that salient means relevant. So you've got to have a look at the relevant features of the case, and there's a list, and there's a text number here, page 222. There's a list of salient features or relevant features that the courts have already found previously, and one of the biggest ones, I think, is the control that the defendant might have over the situation and the relative vulnerability of the plaintiff. So also the relative knowledge and experience of the parties. So basically, if you're in a situation where you're relying on someone's expertise and you're acting in accordance to what they advise or say, you're in a very vulnerable position in that relationship, and therefore where the courts have found that those kind of relationships give rise to a duty of care. So you can say in your answer that that's a relevant feature of the case that's analogous or consistent with the existence of a duty of care. Okay. So that's the next point. Do analogous cases indicate where the courts have held that a duty of care does or does not arise? So think about those points. They're listed on 223 of your text. One of the examples, and I'll just give you an example, is in relation to the control that the defendant has over the situation and the relative vulnerability of the plaintiff. One of the cases for that is Modbury. Modbury, I'll give you the full name. I don't recall it off the top of my head. Modbury Triangle. Sorry, just bear with me for a second. Yeah, Modbury Triangle Shopping Centre in Ansell. So that was a case where Modbury Triangle is a shopping centre. Someone was assaulted by some bad guys in the car park. They tried to sue them, saying that they should have had lights on, but the court found that in relation to the control that the defendant, who's Modbury, had over the situation, the court said, well, look, they're not responsible for the criminal acts of third parties, so it's not reasonable to impose a duty of care upon them. Right. So the main point that the court was making is that, yes, the defendant has to have some control over the situation, and there has to be vulnerability in relation to the control that the defendant has over the situation. And in that case, because they're third parties who are acting, the shopping centre has very limited control over their actions. So they found that a duty of care did not exist. All right. So that's the first element. So the next element that we have to look at is whether there's a breach of duty of care. And here is, breach has been legislated. So we've got section 48, subsection 2 of the Wrongs Act, which goes through these 4 particular points. And these were all in the case law previously. So the case law's been legislated for here. So it's well worth having a look at all of these points and sort of going through them methodically. I'd do that. You might find that some points aren't relevant for that particular question, and I think you can say so. You can just say, for example, if the social utility of in relation to the question that you're doing is not an issue, you can just say that that's not relevant, but it's worthwhile just stating that just so that you've covered everything. So the 4 points are that the probability that the harm would happen anyhow, the likely seriousness of the harm, the burden of taking precautions to avoid the risk of harm, and the social utility of the activity creating the risk of harm. So you can use cases to illustrate. So Bolton and Stone, remember, that's the cricket ball case where they found that, yep, there's a risk of injury, but the risk was so low that it didn't warrant the cricket club doing anything about it. And Paris and Stepney Borough Council, that was the case, if you'd remember, where one of the workers who worked for Stepney Council, I think in a machinery kind of shed, already had an injury, and he sued because he wasn't required to wear goggles because he got injured and lost his sight completely. So the court found that in those circumstances, the burden of taking precautions to avoid the risk of harm, given that the likely seriousness of the harm was very, very high in his circumstances, that the burden of taking precautions was very low. So they actually found that the council had breached their duty in that case. So have a look at all the cases. It's really good to know the cases, good to know the facts, because that really gives you an idea about how the courts think about things. And you can use those, if you've thought about the facts, thought about the cases, then that can really inform the answer that you provide when you're looking at a case scenario as well. The third step is that the harm is that the breach needs to have led to the harm. So that's called causation, right? So there's 2 elements for causation. One is that the breach was a necessary condition of the occurrence of the harm. That's factual causation. So that's a but-for test, right? So but for that action, would the harm have occurred? And then the second part that you have to look at is it appropriate for the scope of the liability of the defendant to extend to the harm so caused? That's the scope of liability. So one of the cases that's cited for that particular element, the second part, because I found that sometimes people have a bit of difficulty with understanding that maybe the second element. The first element's probably a little bit more straightforward. It's just a but-for kind of situation. But there's a good case for the second element, and that's Rowe and McCartney. So that's in your text. So that was a case where someone was injured through negligent driving, but so the person was physically injured, but they also had developed a mental illness, and they sought to sue for damages for the mental illness. But the court found it was not that mental illness was not a reasonably foreseeable consequence of the careless driving. So that was beyond the scope of liability. So the court found that particular injury wasn't caused by the breach of duty. So the physical injury was, but not the mental illness. And here it also says, if relevant, explain the thin skull rule. So this is, and it says here that it somewhat contradicts that principle. So it's always good to explore as well. But basically the thin skull rule, or the eggshell skull rule, means that you have to take the victim as you find them. So an example might be, you know, if you scare someone that has a heart condition and then they suffer a heart attack, you're liable. You can't say that, well, most people don't have a heart condition and they wouldn't have experienced that kind of harm. You have to take the victim as you find them. It's just your bad luck, really. So you can see how there's a little bit of a contradiction between the scope of liability and that rule. So that's something that you could explore in your answer if it's relevant. It makes for a good discussion. Yeah. So you can use that. Because there's a bit of a contradiction, you can think about that in terms of counter arguments. Okay, so one person might argue that the injury was beyond the scope, but the other person might say that there are grounds for the thin skull rule to apply. So that's you know, as we say, there's no black and white answer. And we're not expecting a black and white answer, but we're expecting you to think about it. And that's a particularly good example of where you can get some counter arguments in that particular for this particular element. And then finally, conclude. Does it appear that the plaintiff may be able to prove duty, breach, and causation? And if so, they're the three elements. So if so, then that means negligence is established. And then if so, explain what the plaintiff can claim, the damages for pain and suffering, property damage, and any financial loss. So they're the remedies. So as I said right at the beginning, they're the things that your client will probably be most interested in, is what can I get? So it's worthwhile rounding off your answer with that. And then also it's really important to look at defences and remember that there are two defences: voluntary assumption of risk and then contributory negligence. And I think that in every negligence question, and you'll see with the question that we'll briefly go through now, you'll see that a defence is being raised, and I can safely say that in any negligence question you'll have to think about a defence, and that'll form part of your issue. So have a look at all of your defences and be prepared to discuss those in your answer as well. A final issue that you might have to deal with is that of vicarious liability. So that means that, for example, if you're an employee acting in the course of your job, then the employer would be vicariously liable for your acts. Okay, so there's case law on that. It's in your text. Have a look at that. Just have that up your sleeve. It might be something that's relevant for the question in the exam. All right. So here's a practice question. And again, as Brian, I think, said before, it's not an exemplar answer. We're just sort of talking through it. We're thinking about it. So I wouldn't take this in as an example of a high distinction or a detailed answer to the question. It's not very detailed at all. So please don't use this as an example of the standard that we're expecting from you. I think, as Brian said, we're expecting quite a high standard given the time that you've got the exam to do the question. And this is only really to get you thinking about some stuff. It's not, I can't emphasize too much that this is not a model answer. So this question, I mean, it'll be on your slides. You'll get a copy of them, but just very, very briefly, John needed new tyres. He went to a garage to get the tyres. He paid them. He drove the car, leaving the place. He noticed a metallic rattling. He ignored the sound and continued to drive very fast. You'll notice that's highlighted. That's something you can do in your exam, I reckon. You can highlight parts that leap out to you that you think might be relevant. Suddenly the right tyre came off, and he's smashed the car. He's hit his head. He got a fright, causing a pre-existing wound on his forehead. Yep, Susan, I think that's right. Contributory negligence. That's sounded off that alarm bell. The crash has caused a pre-existing wound on his forehead to open and bleed heavily. He calls an ambulance. The wound's going to take a long time to heal, and he'll get a scar. That might be a counter argument, Mark, that girls like scars. You can try and run it. We'll see how it goes. So he needs cosmetic surgery to remove the scar. All right. So investigations reveal that the apprentice forgot to tighten the nuts on the tyre. All right. So that's what caused the tyre to loosen and come off as he was driving. So his car as well got some significant damage. So here you're being asked to advise John whether he'll be able to bring a successful action in negligence against Joe's garage. So look, that's pretty straightforward. It's told you what law you're supposed to be looking at, told you who you're advising and who the defendant is. So John's obviously the plaintiff in this one because he's the one suing. So having a look at the issues, again, the first issue is basically restating the question almost. And as I said before, you're always going to have to look at defences. And although you haven't been asked to, it's always very, very relevant. So it's always an issue whether a defence can be argued. So here we'd say, can Joe's garage argue a case of contributory negligence on the part of John? All right, so if you have a look, yep, there we go. So if you have a look, these are the first two elements. Remember, you've got to prove three elements, and these are the first two. So obviously, this isn't a model answer at all. But this is the process that you have to go through. So it is worthwhile saying that what John needs to do in the law section. I'm just having a look. Yeah. All right. So that's the law. Yeah, that was the law section, but the application is also quite small too. So in the law section, it's always worthwhile saying that John must prove on the balance of probabilities. That's the standard of proof. That a duty of care was owed to him. So the test that you'd apply is the neighbour test. I mean, obviously, first you'd see if there was an established duty of care relationship between a garage and their client, but there isn't. So then you'd have to apply the test, the neighbour test, and also you'd look at the salient features of the case as well. Remember, there are the 2 steps to that test. And you'll notice here that they've named the cases. And then the second part is to look at whether there's a breach in the standard of care. So did the garage act as a reasonable person, that is, as a reasonable garage repairer? So this looks at the risks of admission, the seriousness of the consequences. These are the elements that we went through previously, and there are a couple of cases mentioned there. And then the third element is damage. So did the breach cause the harm? Again, there are the 2 elements: causation, the but-for test, and then the remoteness. So we've gone through that. And then the fourth element, well, it's not really an element, but the fourth part is whether there are any defences available. So here we've got voluntary assumption of risk and contributory negligence, which has the effect of reducing John's damages on the account of his own negligence. So we've got some cases here. So that's the law section. So that, look, the law section, sorry, is quite detailed. What I was saying before about not being detailed is the application part, which we're looking at now. So the application is just the one slide here. So obviously we'd be expecting a lot more in an exam. So here you can see that it's very, very brief. Some of the things that you'd be thinking about is, well, the first line is the duty of care test. Obviously, that would be in more detail. You talk about reasonable foreseeability of their acts or admissions causing harm. So I think that you could establish that there's a duty of care. You consider the fact that the garage didn't do their job by tightening the nuts properly. So you'd go through all of the steps that we looked at before. The seriousness of the potential harm. You'd look at the burden of taking precautions. I mean, in this case, you'd think that it wouldn't be burdensome to do a brief check that you've tightened them all properly, that you've had a review of the work that you've done. It's not going to be tremendously burdensome to the business to be able to do that. So those elements you could look at to evaluate whether the garage acted as a reasonable person would have in those circumstances. I mean, given that the risks of, or the likelihood of the seriousness of harm that might occur should a tyre fall off whilst driving at speed on a road, you'd think that the risks were pretty high, and that would outweigh any burden upon the garage to check their work and check that the work was done properly, or even you could also raise issues about the supervision, because I think that it was an apprentice, wasn't it? Just going back. Yep, so it was an apprentice that changed the car's tyres. So there's issues in relation to perhaps their supervision that you could talk about, the appropriateness of that occurring. So they're all factors that you'd consider in terms of whether a breach had occurred. And then looking at the damage, you have to look at the 2 steps, the but-for test, and then also the remoteness. Here, there is a little bit of a question in relation to that, because we know that he already had a wound on his head, but the garage would be responsible for I suppose, the damage that they've caused on top of that wound. So that would include the scarring as well. They might say that, again, and this is where some counter arguments could be made, that they're not totally liable for the head injury. It's not a distinct and separate injury. However, you'd think that they would be liable for the additional injury that they've caused. So these are things that you can explore in more detail. So the damages would be awarded for the injuries, the scar, and the future treatment, and also the damage to the vehicle. So that's what the court might find in terms of this of a finding that negligence has occurred. But then having a look at the defences, one of the crucial things, and that was picked up on before by Susan, was that he was driving at speed. We clearly know that he heard some rattling and he didn't slow down and he started driving faster. So there's an argument that could be raised that he's contributed to his own injury, because a reasonable person would have slowed down, stopped the car, or got it checked out. And as he's contributed to his own injury, the damages that he would have been awarded would be reduced, and the court would work out a proportion. We're not really asking you to work out a proportion, but courts would do that. So they might say, look, we find that there was negligence on behalf of the garage, but John contributed to his own injuries, so we make a finding that he was 40% at fault. So the damages that the court would award would then be reduced by that amount. Okay, so the final conclusion, this conclusion is basically restates all of the elements. You've gone through all the elements and come up with a conclusion that damages are likely to be awarded for those particular things, and that the amount may be reduced due to his contributory negligence. Okay, so that basically just sums up your application. And also, as we said before, it talks about the remedies that would be available to him. Okay, so have a look at the weekly practice questions. And I think, as Brian said before, a good way of approaching that is to try and do them under exam conditions, which is to time yourself. So you've got some suggested solutions. If you haven't had a look at them already, it's well worth looking at the question, putting together a solution in exam conditions, and then you've got the opportunity of having a look at the suggested solution and sort of assessing your own response. Assessing your own response. Be familiar with these areas. We've given you the topics that are part of the exam, so that gives you a big heads up, obviously, and a bit of, hopefully a bit of confidence going into the exam. You know that you're not going to get any nasty surprises, but you do need to be very familiar with these topics. Okay, so it's right on 8 o'clock. Does anyone have any questions before I hand back to Brian? No? All right, well, thanks everyone. I'll hand back to Brian now.
Thanks a lot, Paul. That was great. And Paul has been undergoing the dreaded lurgy, so thanks very much for soldiering on there and doing such a great job. And we've come to nearly the end. The end is nigh, in both the sense of the TP and this show. So I just wanted to say to everybody, and I'll throw to Paul shortly to say the same to everyone, and especially our own groups. But well done, everybody. You've reached nearly the end. I think this is our last week of new material. So next week is revision week, and then it's over to you. So we do hope you enjoyed it. And if you think we are any good, don't forget to do the survey for us. Much appreciated. And I have to say, to those of you who say such nice things usually, thank you. By the time we get the surveys, you've gone on to other units, but I do through them. I don't know who said what, but I go through them to make sure that there's any way we can improve, or if we did right or well by you, which is always what we're trying to do. So thank you. Thank you for being here. Thank you for sticking it out. You're the superstars. You've made it to the end. I always say, what did he say? Stealing from our beloved ex-Prime Minister. I'd rather be a loser than a quitter. But yes, I hope you enjoyed it. I hope you had fun at least a little. I hope you found it useful. Maybe some people have even claimed that they're watching Parliament on TV now, as it's got a certain interest for them. And just a quick reminder that at the end of week 12, the ELAs are off, riding into the sunset, and that you will have space then, breathing space to revise. But yeah, I'll be around, and I'll definitely check in on the boards just in case, maybe not as often and as quickly as normal. And I want to wish you all the very best of luck on a final note. Good luck in the exams. I know you're going to do it. From what I've seen of the assignments, you're going to ace it. You'll do well. And hopefully look back on this unit with joy and happiness in the future. And I'll just throw to Paul if he's got anything to say in closing. Over to you, Paul.
Yes, thanks, Brian. Thank you, everyone. It's been an absolute pleasure to be ELAing and to be doing these collaborate sessions as well. I think this has been a fantastic group, and I'm really, really pleased with the work that you've done, marking the assessments. It always gives me a thrill to see people do really, really well, and I've seen that in spades, which is really, really good. So that makes that's really why I like doing this job. So thank you very much for everything that all the contribution that you've made. I think that you're on track to do really, really well in the exam. It's going to be a bit of hard work, so it's not over yet, but I'm sure that you can go in with a bit of confidence, and I'm sure that you'll do really, really well. So thank you, everyone. Good luck, and I'll be around on the boards, but I won't be speaking to you before the exams. So best of luck with the exams and with your courses going forward. And as a bit of a plug, there are other law units. There's a unit on that covers contract law again, and also corporations law, and Brian's the UC for that. So you can get a bit of get a little bit more of a fix of law with us going forward. All right, so thanks everyone, good night, and see you soon.
Yes, thanks everybody. I'll just pick up on a quick question that might have got lost from Susan. I did mention earlier, Susan, results for 1B will be out latest next Monday midnight. 2 weeks is the deadline, but if we can get them before, we will. But we do have to go through a kind of long, involved moderation process that I was describing earlier. And just going through them again, thank you, Sophia, for saying that. It's very kind of you. Thank you, Rachel and Jane. Good night, everybody. And have a great week, and we'll be seeing you around on the boards. Night, Susan. I think Sophia and Stephen are typing.